Good morning, everyone. Okay, yeah, now I forget some people are on mute. Good morning, Silindile.
Good morning, Taki. Good morning, everyone.
Good morning, everyone.
I just want to test if my camera stuff is right.
Morning, Takalani.
Morning.
How are you?
I'm well. How are you, Ronel?
I'm good, thank you.
Good.
Nervous, but good.
You have nothing to be nervous about. You know, I've been saying to everyone, especially for the funds, that you probably know more than we do. So, you know, it's like subject matter for you. You wake up with it and
Yes.
you know exactly what's going on. So it's very
We
nice.
dream about it.
You definitely a lot more worried than anybody else, especially for your own fund, right?
Yes.
It was very interesting meeting with everybody to hear about the different funds, because there were things that we just, you know, didn't know before, which was really, really nice as well.
Well,
Yeah.
the great thing about life is we're never too old to learn anything.
So
Every
true.
day we learn something.
So true.
Morning, Verwey.
Ah.
Your mic is off, Verwey.
It's just still on mute.
Yeah,
There we
it said, yeah, morning. No, it said, yeah, only the organizer can unmute, but I think you've unmuted me now. Somebody did. Thank you.
Yeah, no, you're part of the speakers, so yours is the same as Ronel's. Yeah.
Thank you. Okay,
So
I
yours
just
is
saw
all
now I
right.
can. Yeah, excellent.
Yeah.
Good.
All right, I think we're just waiting for, last time we had very, very good attendance, and I'm hoping that we will have the same today, because that just means we get our message out a lot better as well to everybody. So we'll just wait a few minutes, probably just like past 9, 5 minutes past 9 or so, and then we can get started. But thank you so much.
Tell me, how do I share? Yeah, I don't have a share button. Under my options, it doesn't have a share option. See, my firm don't have Teams. We will use Google.
Oh, okay. I actually don't know where, because on our side where you've got the leave button on the side, right next to it is share.
You see, I don't have that.
Yeah.
Shall I send that? Who should I send it to? Should I send it to Keabetswe?
Yes, Keabetswe would be great. Thank you.
Okay, let me quickly. I'm just gonna during the call we put our cameras off, right? Only when we speak we switch it on. Okay, let me switch off and let me quickly mail that to her.
All right, thank you. Morning, everyone who's coming in. Thank you so much for joining us this morning. We're just going to wait a few minutes for more people to come in, and then we'll get started probably at around 9:05, the latest. Wouldn't want to hold back for those people that did actually join on time. Thank you. Good morning, everyone that's just joined. Nandi's now told me that because we changed the previous one, we just sent a meeting request, and this time around people had to register first. It seems that a lot of people might have missed that for this particular webinar and didn't register. We will get started on time on our side. And as people join, then we will just let them in. But there will be a recording, so we'll just let them know that as well, that they will be able to catch up with everything else anyway. I wanted to quickly share the program. And I see there's a change on my side. I'm just sorting out getting the updated program and then we will get started. Thank you. Good morning, everyone, again. And thank you so much for joining us for part 2 of our webinars with the bargaining councils and our industry funds. I think we have about 2 industry funds or 3 that we know of. So there's private security sector, contract cleaning, and there is also another contract cleaning fund in Durban, I believe, but that's a bargaining council. Otherwise, thank you very, very much again for joining us this morning. Today, we are going to cover a few more items that we got from a lot of the discussions that we had with the some of the bargaining councils in preparation for these webinars. And today our program is very, very practical in the sense that it's topics that we know you deal with on a regular basis. So as you can see from our program, we have got the registration and deregistration of participating employers. There was an information circular that had gone out on how to deregister and what information would be required by the authority for us to do that. And I know some bargaining councils had a lot of questions around that. And so we just needed to make sure that we could give you some more information as well on that. There are some people that are typing in the chat that they can't hear me. Nandi and Kia, for you that do have your mics on, can you hear me?
I can hear you.
Okay, thank you, because I am on load. Yeah. Thank you. I am on load shedding, so I want to say I wouldn't have been surprised if my connection wasn't great, but it should be holding steady. And then we've got the structure and challenges of opportunities from the Electrical Bargaining Council. So they will just go through, as we did in the previous webinar, just to go through some of the challenges that they face. It was a very interesting discussion that we had with them on some of the issues, and it wasn't just on contributions, but also even on unclaimed benefits. And then we'll have a discussion on accrual versus cash. I know we get a lot of reportable irregularities or non-compliances that are reported by the auditors on the fact that some bargaining councils or most bargaining councils actually work on cash instead of accrual. And then we've got the conduct standard. So Kia will then take us through the new conduct standard. I know we had a very, very, I want to say long debate just at the end of the last webinar about the calculation of the interest. So today we'll clear that up and still provide a note. But I want to hand over to Silindile already so that we can get started with the webinar. And Silindile is in our reviews and authorizations department, which looks at the rules and registration of participating employers, and would also be looking at the deregistration of participating employers as well. So thank you very much, Silindile, for making the time for us today. Just a few house rules, sorry, before we get into your presentation. Your mics are muted, and I think we will have Silindile deal with your questions for a short period of time after her presentation. Otherwise, she will be available at the end of all the other presentations as well and throughout for any questions that you might pose. Some of the questions you can also, as we go along, put them in the Q&A, and my colleagues and I will attend to them. And yeah, I think that might be it. Again, the recordings will be available, but at the end of all the webinars, so that at the end of next week's one, we will then collate all the information and put out all the information on our website. But I'm definitely going to hand over to Silindile now. Thank you very much. And please do enjoy the day. If you've got any questions, or just, you know, anything even housekeeping wise, please let us know. And to myself or to Kia or Nandi, and we will then attend to that. Thank you so much.
Thank you, Taki. Good morning, everyone. As Taki has alluded, my name is Silindile Sebotsa, and I'm from the Reviews and Authorizations Department. My presentation will be very brief. I will be taking you through the registration and the deregistration of the principal participating employers. And my presentation will include the following. I'll just turn off my camera so that I can just, you know, focus on the presentation. Kia, thank you. Next slide, please. So the contents of my presentation are there will be an introduction. I will then just briefly explain the registration of participating employers, and then the role of participating employers. Then lastly, the deregistration of participating employers. And as Taki has alluded that, I will just briefly also highlight the requirements in terms of the Information Circular 2 of 2017. Thank you, Kia. So the Pension Funds Act defines an employer as an employer who's participating in the fund. The registration of employers take place in terms of Section 12 of the Pension Funds Act 24 of 1956. Employers can participate in standalone funds or umbrella funds. A new employer then starts participation in a Type A umbrella fund when the FSCA approves the employer's special rules. The Info Circular 2 of 2017 was implemented to provide clarity on the requirements for the termination of a participating employer in a fund. And I will just be going through those requirements as I continue with my presentation. Next slide here. So the registration of participating employers take place in terms of Section 12, as I've highlighted, and through the submission of special rules, which will then land in our department, where we will analyze and just check if the special rules actually comply with the provisions of the Pension Funds Act, and also just to ensure that the special rules are actually in accordance with the rules of that particular fund. There is information that is required when we, or the information that we look at when we are considering the registration of special rules. And I will just mention what we really look at. Firstly, the special rules must state the name of the participating employer, We also need to see the address on the special rules of the participating employer. The eligibility requirement also has to be, we need to know who is eligible to be a member of that fund, or who will be eligible to participate under that participating employer or under that fund. Then the special rules must also state the normal retirement age, which is in most cases between 60 and 65. They vary from each participating employer. And also the contribution rates by both the member and the employer need to be highlighted on the special rules. And then the rules must be accompanied by a resolution, which must be taken in terms of, which must comply with the provisions of Section 2 of Section 12, subsection 2 of the Act, which states that the special rules must be submitted to our office within 60 days of passing the resolution. And lastly, the certification should be that the certification should be signed by the chairperson of the fund, one trustee, and the principal officer of the fund. So these are some of the things that we look at when we are actually considering or registering the special rules. Thank you, Kia. Upon registration, once the FSCA, or once we are actually satisfied with the special rules, we then approve and register the rules. Then the participating employer and the members now have rights, powers, responsibilities. However, these rights and responsibilities are still governed by the actual rules of the fund. Thank you. Thank you, Kia. I see there's someone in the chat box who's saying that there's no audio. Just by a show of hands, am I audible, colleagues? All right, thank you. So after the registration of participating employers, the participating employers have roles that they need to fulfill. They must not, without good cause, conduct themselves in a manner calculated or likely to destroy the relationship of confidence and trust between the employer and the employee. The participating employer must not exercise a veto power capriciously, meaning that they shouldn't just decide what they do with the affairs of you know, the members. They need to act in accordance with the rules, not what they think is right or might be right. And the participating employers must not adopt a rigid policy in regard to the exercise of its rights, meaning that the employer must be willing to review its position in changed circumstances. Section 13A, subsection 1 of the Act mandates employers to pay money deducted in terms of the rules of the fund from the employee's remuneration over to the retirement fund. And lastly, the employers must make all the required contribution payments timeously. They need to make payments timeously, as this is a requirement in terms of the Act. Thank you, Kia. Then we will move to the other part of this presentation, which is on the deregistration of participating employers. The deregistration of participating employers take place in terms of Section 27(1) of the Pension Funds Act, as well as the Info Circular 2 of 2017. There are different reasons where you'd find that the participating employer is terminating, and one of them, or a few that I have highlighted here, are that a participating employer may be terminating because of there's a Section 14(1) or Section 14(8) transfer. It could be that the last member has exited the fund, or that the participation never commenced, or there was an exemption in terms of Section 28. Thank you, Kia. Then there are requirements, as I've highlighted, in terms of Info Circular 2 of 2017. And under the reason that the participating employer is terminating because of a Section 14 transfer, the following documents need to be submitted to our office in order for us to consider the termination of the participating employer. The declaration, firstly, is the declaration by the chairperson of the fund, The format is found under the circular, and it is important that all the contents that are highlighted in this info circular are included in the declarations that are submitted by the funds to our offices. And then we also need a section 14.1 approval letter. So we need to know that there was indeed an approval that the funds were transferred from this fund to the other. And then an extra B, which is also included in the info circular, it just highlights the minimum information that we need to know about the fund. We also, in instances where the fund is terminating because of a section 14.1, we also need Form G. And where there's the reason is because of section 14.8, we need a Form H and a Form J. We also need a disclosure of assets, maybe a statement indicating that the fund does not have any assets or liabilities left. Then in instances of for those participating employers who commenced to participate in the fund prior to March 2002, we also need to get a section 15 surplus approval letter, which states that the fund is a nil scheme fund. So this is only applicable to those funds that commenced participation in funds before March 2002. Then lastly, for us to consider the application, we also need to have a resolution submitted to our offices. Thank you, Kea. In instances where the reason is that the last member has exited, we need the declaration by the chairperson, which is also included in the info circular 2. Usually it's the C, it's not usually, it's the C3. So it's very important to, when you submit, you look at your reason and you submit the correct declaration. So for last member exited, it's C3. We also need to receive proof that the last member was paid and that the participating employer has no assets or liabilities. An example of proof that can be used is a payment letter issued to the last member. We also need an extra B, which is, as I've highlighted earlier, it contains the minimum information about the fund, and also section 15B approval letter that is still applicable to only those funds that those participating employers that commenced participation prior to March 2002. And lastly, the resolution. Thank you, Kia. And then you'd find that there are instances where a member would submit their special rules to our offices and we get them registered, and only to find out that for certain reasons, maybe the member never commenced participation in the fund. So now they then apply to our fund. The reason will be that participation never commenced. Under these circumstances, we need declaration by the chairperson, which is a C4, and also the declaration by the representative of the employer, which is another C4. So in this case, we need 2 C4s, a resolution and an extra B in order for us to continue with the termination of this participating employer. The other requirements are not applicable because obviously the business never commenced, therefore we cannot ask for section 15B and all that. Thank you, Kia. And then the last one is where there is a section 28 exemption. We only need from our side, from my department, we need the declaration by the chairperson and the resolution in order for us to now continue with the deregistration of this participating employer under this reason. Thank you, Kia. And then the effects of deregistration is that obviously the employer becomes inactive, and the authority shall terminate the participating employer on proof to his satisfaction that the employer has no assets or liabilities and has ceased to exist. So before we actually terminate a participating employer, we need to make sure from our side that indeed there are no liabilities left, there are no assets, and indeed this participating has ceased to exist. And once we are satisfied with that, then we continue with the termination of the participating employer. And then the result would be that once we terminate this participating employer, they no longer participate in the fund. And therefore, there will be no contributions made to the fund by this employer or its members, and no funds can be transferred in and out of the fund on behalf of this participating employer, and then their status becomes cancelled. Thank you, Kia. I think that's all from my side. Yes. Thank you so much, colleagues. That would be all from me.
Thank you so much, Silindile. Just a quick question, and I don't know whether you will be able to answer it immediately or if we will just need to if we'll need to come back to it a bit later. For the bargaining councils, especially in reporting for the arrear contributions, there is a process where the participating employers must be registered online. Is there somewhere where we have provided the process or the link where they can actually do it on our website so that it makes reporting for them a lot easier when they report online, that we already have their participating employers, even though they are type B umbrella funds?
Oh, thank you, Taki. At this point, I'm not aware of any link. However, I will find out, and as soon as I get the answer, or maybe if there isn't, maybe we can have a discussion and just find out how we can actually make it easy for them. Then I'll get back to you as well. But at this point, I have there is no link where they can actually make these submissions. Thank you, Taki.
Yes, I think there is I'm scared to try and I'm scared to waste time now for everybody else who might actually want or might have questions. But it is very important, especially for the funds, that we get a list of the participating employers. Am I correct, Silindile? Even if it's a type B, there is a place on where it's also important even for things like unclaimed benefits or where a person is looking for their benefit, that on our system, we then record who the participating employers are. So it will be very, very important for us to be able to do that and for you to report a lot easier, even on the 13As, because it will all be done online. I know a lot of you struggle, even when you are reporting through the spreadsheet on your arrear contributions on the reference of the participating employer. And you would get that reference if you submitted the participating employers online. So what I will do is just make sure either at the end of the session or perhaps just to include a quick demonstration for the next session, and also give you a document that you can use going forward with a step-by-step guide just on how you can upload your participating employers, so that it makes it a lot easier for you to report your unclaimed benefits, your paid up benefits, and your Section 13A contraventions. Kia, I see your hand is up.
Thank you, Takalani and Silindile. There's just a question from Mr. Gordon Moing in the chat box, and he's asking, for registration of participating employers, is the CIPC registration certificate a requirement?
Thank you, Kia. Not necessarily. When they're submitting the special rules, it's not really a requirement. However, we only require when, for example, this participating employer has now been registered and they are changing their name. That's where we actually ask for the CIPC document. However, when they submit the initial special rules, we look at the special rules. There's an annexure B that also needs to be accompanied by the special rules and the application letter. So the CIPC, when submitting the initial set of special rules, is not really a requirement. Thank you, Kia.
If I could just add as well, Mr. Moing, I think it's important that the fund gather that information from the beginning. One, to avoid having an umbrella within an umbrella. So just to make sure that the company structure is correct and that the information that the fund has, especially on commercial umbrellas, I don't think it happens a lot with the bargaining councils, but we've seen where in some instances, a holding company registers its divisions as pay points instead of registering them as separate participating employers. So that registration number is very important. Also, in relation to reporting arrear contributions and going after the responsible party, that information will be required when you submit your notification of arrear contributions, because it's very important for us to know which legal entity has actually contravened, and that you can really get as a unique number from that CIPC number. So, and we use it from time to time, just to check who the directors are on some of the notifications that we get, to make sure that we can at least see that the fund has reported on, one, the correct name of the participating employer registered as the company, and two, that at least one of those people is actually the directors as registered in CIP. So it's a very good check on our side. And hopefully one day, if our systems are as wonderful as we'd like them to be, we will be linked to CIPC. It's a wish list, obviously, but it would be linked to CIPC so we can also verify that information upon registration, so that it's not a manual process for the funds as well going forward. Yes, yeah, it's a wish list on our side. Yeah, but I hope that assists a lot. But I think the fund definitely needs to collect that information from the word go, so it has all the information that it needs. Silindile, did you want to add?
Yes, I just wanted to say the Annexure B that I referred to actually has that information. It's the registration number, the legal entity type, and all that. So yes, we don't necessarily ask for the certificate. However, the information has to be included in the Annexure B that is submitted with the special rules. So I actually concur with you, Taki, on that one.
Thank you very much. I see there's another question from Gary Wilson. He's asking, what is regarded as contributions having to be paid timeously? That is paid by the 7th. So by the 7th of the next month for which the contributions were due. So anything before the 7th would be paid timeously. So it's basically paid within the statutory prescribed period of time. I hope that helps, Mr. Wilson. Unless there's an additional question, if you put your hand up, then we can perhaps address it if there was something that you needed to clarify in relation to that as well. Okay, so I see there is a hand up, Gary Wilson. Gia, can you please unmute Mr. Wilson, and then he can ask his question. Thank you.
Mr. Wilson, your mic, yes.
Can you hear me?
Can you hear me? Okay, we can hear you now. It's a bit soft, but we can hear you.
Okay, thank you. The reason I'm raising the question is that we are, as bargaining councils, we are all in different industries, and our industry in particular has got huge challenges in that lots of times the employers are dependent on government to pay them for services rendered, and it places our employers, participating employers, in huge problems because they're not able to pay before the 7th or by the 7th because government pays either 30 days later or they pay on the 30th. And the reason I'm raising this question because our council and our board has challenges in that we continuously have LPIs just adding up, and it adds up into millions of rands because employers are dependent on government to pay them. And the FSCA rule seems to be very stringent. I mean, there don't seem to be any discretion when it comes to that for bargaining councils to apply. And it just places us a huge burden on the bargaining council, and we have to go after these employers sometimes unfairly because they are not in control of when they receive their funding from government. And then when they pay late, there's LPIs that constantly rises. So the reason of my question is, is there anything the FSA has considered in this regard? Because we'll just continue having LPIs add up and add up and add up. And at the moment, we're having to attach people's assets just to recover LPIs because the rules of the FSA is clear. If you don't pay by the 7th, there's LPIs that accumulates. And now we're sitting with the situation that some of the employers are having to close their businesses down because of the type of LPIs that they owe. I mean, we have one company that owes 4 million rand in LPIs over the last year. Now, I mean, if we continue in this way, bargaining council funds will never be able to survive, especially in our industry, because of the fact that we provide a service to the public and the government subsidizes that. And the rules of the FSA says, if you don't pay by the 7th, then there's LPIs. So I'd really like to get some, input or some direction from the FSA in this regard. Thank you so much.
All right. Thank you so much for your question. So I just want to clarify one thing. So from our side, we administer the Pension Funds Act, right? And the Act says the contributions must be in by the 7th. But and I had really thought all of the bargaining councils were aware that they could actually ask for an exemption from that prescribed period because it wouldn't be practical for some of their participating employers, and in the manner in which bargaining councils operate, that you collect monies on behalf of different, sick pay fund or the holiday fund or any other things. And then you have to, as a bargaining council or your administrator, to then make sure that the money goes where it's supposed to go. A lot of the bargaining councils had already applied for an exemption, and that exemption would be based on what the fund feels is practical for their participating employers. I know a lot of funds have got it the 15th, or some have even got it 30 days, if I'm not mistaken, on some of the funds as well. So all you would need to do as the fund is amend your rules, right, to then cater for the fact that it's not going to be the 7th. And then you would need to, together with that, apply for an exemption so that your rules match your exemption. And as far as I know, and I'm just checking whether on my side, I haven't checked participants, but maybe Silindile or Elvis can confirm. But as far as I know, and it's definitely something that we're applying, the bargaining councils work on the date that is suitable for the majority of their, for the majority of the bargaining councils. A time limit is important because you need to be able to know when someone is going to contribute. So you can't leave it open-ended because, then you never have any certainty. But if you at least, cater for 99% or 100% of them, and then you have someone that's late after the 20th, then at least it's not the majority of them that would be late. So you would definitely be able to apply to us for us to grant you an exemption from that particular provision of the 7th, and then you would need to submit what you would think is practical based on, how many of them are contributing at a particular time. And then between ourselves and you as the fund, we then work out what would be the most advantageous to the members. Like I said, there has to be a time limit somewhere. So you would then need to be able to do that, at least to be able to provide some period that we can work around. All right. I see you've already responded to say that you were advised that you could not apply for an exemption. That's definitely not from us that you were advised, but please, I think it's very important, even for the webinars and everything. One thing that we're realizing quite often is that it's good for us to have these engagements directly with the funds, so you can hear it from us. And whatever advice that you receive at any point, we can't give you advice, but at the very least, we can clarify according to the law what is required. So please double check anything with us, just so you know you're on the right track in terms of legally what you're applying, but you can apply for an exemption. And I see Meryl has also commented in the chat to say that the Transport Sector Retirement Fund has actually ensured that their rules match the council agreement. And that's in most cases what also happens, so that the employers have got one time period that they know of, and your rules are not in conflict with your council agreement. I can see that there's one more hand up, but we have run into Ronel's time for her to do her presentation. I'm just wondering if Mr. Mahlalela, can you keep your question in abeyance just a little bit so that we can get to Ronel's question, and then we will get back to you, or Ronel's presentation, and then we can get back to you on yours. If you don't mind, you can also put it in the chat, and then we can take it from there as well. Ronel, I'm hoping that you are ready. I know you are. I'm going to hand over to you now. Ronel is from the Electrical Contracting Industry Pension and the Provident Funds, and they will just go, or she will just take us through some of the challenges and the structure of their fund and how they're addressing their contributions and non-contributory members as well. Thank you so much.
Good morning, everybody, and thank you for this opportunity. Can everybody hear me?
Yes, we
I
can.
can hear you, Gia. Oh,
Okay.
yeah, not Gia, Ronel.
Yes, it's been really, really interesting. I think bargaining council funds is a very challenging environment for everybody. So I will go through a couple of, just as way of background. I've been involved with bargaining councils basically my whole adult life. So I started about 25 years ago. So I've basically grown up in this environment. So yeah, I eat, sleep, and live bargaining council. So thank you. Can everybody see my presentation?
Yes, we are able to see it, Ronel.
Okay,
Thank you.
So today I'll be speaking about bargaining council funds and trying not to repeat what everybody else have already covered. Then the agreements that's extended to non-parties, I think that's an important challenge to look at. And then the different industries. And then specifically 13A, dormant and non-contributory members and questions. So it was very interesting the other day when the gentleman started these sessions by saying that bargaining councils have existed since 1957. So a lot of the issues that we face are legacy issues because it's been around for so long, and the Pension Funds Act specifically only became applicable to bargaining council funds in 2007. So just especially I know there's a lot of bargaining council people in the room, but for those that are not familiar of how it actually works, very shortly, you have party employer bodies. Then you have party trade unions. So they willingly come together and negotiate what's called an agreement. The agreement typically looks at the employment conditions in a specific industry. They then approach the Minister of Labour. The Minister then extends that agreement to non-parties. And it's important to note that these non-parties, in most cases, weren't even aware that negotiations were taking place. So one day they wake up, they didn't agree to anything, and they are now pulled into this little funnel, and they are required to belong to a bargaining council retirement fund. So what happens when agreements are extended to non-parties? Non-parties are now compelled by law to become participating employers and members of bargaining council funds. In reality, there are periods where agreements are not extended to non-parties for various different reasons. It could be sometimes up to a year. And the minute that they hear that it's not extended, they stop contributing. So my question, and I think it was Richard's question the other day, can Section 13A still apply? But we'll get to that in the end. So even if agreements are extended and fund participation is compulsory, non-parties see it as a grudge purchase, and engagement from the fund side becomes very difficult. Then the different industries. Every bargaining council covers a different sector of industry. Wages contribution rates vary from your higher skilled industries to industries that require lower skilled employees. The macro and local economies impact differently on each industry, impacting employees' profitability and ability to afford contributing to the funds. A good example is the clothing and furniture industry that has been highly impacted by cheaper imports. I would implore on everybody, and I know it's difficult, but buy local. So some industries are more formalized than others. Typically, a metal engineering company is not able to operate from a bakkie, but in other sectors, it's easy to have your office in a bakkie, making it more and more difficult for bargaining councils to actually ensure compliance. The barriers to entry for each industry differs. This is again related to the required skills in an industry. I cannot, for instance, open up an electrical company because I will blow your house up, but I can tomorrow go buy a bakkie and get a couple of painters from the road and open a painting company. Some industries are project-based, so once a project is finished, the employees are typically unemployed until a new project is started. This also makes it difficult in terms of 13A because you're not sure if the employees are still employed or not. All of these factors make it difficult to bundle bargaining council funds into one group. The rules of engagement may be the same, but the players all play a different sport under different conditions. So the one company is playing cricket in the rain, the other one is playing at the Soccer World Cup, but they're all governed by the rules of the sport. And again, these different industries and the differences between bargaining councils is very important when comparing the success rate of bargaining council retirement funds in Section 13A matters. Yes, so part of this was to look at the 13A opportunities which I struggled with. I have to admit, when the amendments came out in 2014 or thereabouts, I literally ran through the hallways and said to everybody, finally, we can put these people in jail. We have now, everybody always says bargaining councils don't have teeth. So I said to staff, we now have teeth. But since then, it's been extremely, extremely difficult to actually implement this. We've been to the NPA, we've been through various police stations, etc., and we are now finally having some success thanks to a reasonably cost-effective firm of attorneys. And but at the same time, I think we need, as bargaining council retirement funds, get together and try and raise public awareness of what we are doing in terms of 13A. Because in the long term, we need to look at the costs. We cannot take every single employer that's in contravention to a lawyer and take them on criminally. The costs will just be impossible for members to bear. So we need to look at a way to make the public aware that if you drive through that red robot, you will get locked up. So we need to make sure that industries are aware that we are doing things like a scare tactic, which I think the law was intended to be. Then another problem that most bargaining councils face is dormant and non-contributory members. So as I mentioned, bargaining councils in whatever form has been around since 1937. So the bulk of our fund's current dormant members are due to historical difficulties in communicating with members, lack of ID documents with respect to certain members, and a general disregard from employers to obtain or provide the information to the fund. So it's all good and well saying that the employers must provide or shall provide, but for a bargaining council, it's not always easy to force an employer to give the information. And in addition to that, the employees themselves don't always come forward and give them. In an ideal world, it should work like that, but we live in South Africa and it just doesn't happen. So tracing such members or all their beneficiaries remains problematic with a low success rate. Alexander Forbes, in their experience, if members are not traced within 24 months, there's only a 10% chance of finding them. Data shows that 49% of unclaimed monies are older than 8 years, and tracing has been attempted more than once. The FSCA has reported that there's 4.8 million members that have not yet claimed their pension. According to the FSCA, the reasons are that many dates back to the 80s. So if we look at the legacy of this country, that's an important date because during that time, there was a lot of labor unrest, there was all sorts of things. So a lot of it came from that. Then there's the difficulty in tracing beneficiaries. People don't necessarily understand that their grandfather worked in the electrical industry and there might be money there for them. And of course, people change their addresses or they don't have ID numbers or a traceable address. The situation is not unique to this country, however. In the UK, they have up to £1.4 billion of unclaimed money. And the industry says that the efforts to trace vary and there's no agreed best method. So they are struggling with the same issues. So from an admin perspective, non-contributory members could be flagged as dormant, resulting in members not being aware that the employer is not contributing, because typically an administrator won't issue a benefit statement to a dormant member. So communication with members remains a huge problem, both in terms of dormancy and 13A. Members change cell numbers very often, and there's typically no postal service available. So bargaining council funds rely heavily on employers to convey fund information. And in that is a conflict, because if the employer is in contravention, he's not going to, he or she, I should say, won't convey that information to the employees. I know that was very short. I didn't want to overburden people with quoting laws, etc., but I have two questions for the FSCA in particular. So in reality, there are periods where agreements are not extended to non-parties. In other words, by law, they are not required to belong to the fund. And these employees, in some cases, not all, are very quick then to immediately stop contributing to funds. So can we then still apply 13A? And then the second question, and this comes from about 20 years ago when the Labour Relations Act was still a criminal offence if employers didn't comply. So in one instance, the bargaining council actually jailed an employer successfully, but the regional manager, and bearing in mind I was then in the accounting side of it, I just wanted to clean up the books. So this employer was sent to jail for not complying, but then the regional manager refused to write off the money.
Okay.
So if an employer has gone to jail, for argument's sake, are they still liable for the contributions?
Right. Thank you so much, Ronel. I'm trying to catch up with social media and I see the fund is already on TikTok. My goodness. I'm not even sure I know how it works, but I'm glad to see that there are different methods of members being able to contact the fund. In relation to your first question, on whether they would be compelled to contribute to the fund. And obviously I'm going to need a little bit of help from you to also just make sure that I understand, how the agreements work. But do the agreements go together with their conditions of employment for those particular employees? Because if they do, then the employer would still be required to contribute, because in terms of their conditions of employment for those members, they have said that they would be contributing to the fund. So until they change those conditions of employment, regardless of whether there's actually a agreement or not, they would still be required to contribute. They can't just stop, because the members are still then expecting, in terms of the conditions of employment, that there is a fund for them. So 13A would apply until those conditions are amended. Is it correct that the conditions of employment would be aligned with the agreement as well?
That's correct, but
okay.
Keeping in mind that if the agreement is not extended to non-parties, those conditions no longer apply.
Okay, then
that is the problem.
Then yes, if eligibility is tied to, I think you mentioned earlier in your presentation in terms of eligibility as well, or maybe it was Silindile, but if eligibility is tied to the agreement and it's recorded as such in the rules as well, then chances are it might not apply. But I think it's a very important question that we make sure that we get clarity and certainty for you around that answer. And I wonder whether there are other funds that have come across the same thing that might be able to offer their experience, and whether they, perhaps got a legal opinion or something and can provide clarity based on whether they received legal opinion or not. I see we've got a hand up from Carmen. I don't know whether she was responding to that, because the previous hands were, or the hands that were raised already there were in respect of the previous session. So perhaps, Kia, if you could unmute Carmen Jefta, and then perhaps they have from their fund's experience an answer for us on this particular question as well.
Carmen.
Sorry.
You can go ahead.
Thank you, ma'am. Good morning, everybody that is in the webinar this morning. I must be honest, very interesting. Our principal officer asked me to join today, and I'm very glad that she did. I was actually responding to the issue raised by the lady, and I must say she did an excellent presentation, succinct and to the point. Thank you for that. What our experience and learning has been in terms of an interregnum period where the collective agreement is not extended to non-parties is that the main collective agreement has is gazetted for a certain period of time on an annual basis, or a biannual basis, depending on how often the parties negotiate. The amendments to the agreement gets gazetted. Now, there are instances where the amendments is not extended due to some, whether it's a representativity problem or whatever problem the department picks up. But normally it doesn't mean, so I think that is the short answer, is that the main agreement stays in place, because we cannot have, there is in law no situation where there is no conditions of employment at all. So which means then the current conditions stays in place. Your gazettal process, an extension process, is only related to newly negotiated terms and conditions. If those newly negotiated terms and conditions are not amended by the new gazettal, then the previous one stays in place. And now I'm explaining it a little bit haphazardly, but the fundamental is the law says there can't be a period where there is no conditions of employment. So effectively, even if you can't enforce the increased contributions because of the non-gazettal or non-extension, you can enforce the current contributions. So I just wanted to say that. I hope it was helpful. Thank you, ma'am.
Thank you very much, Carmen. I see there's also a hand from Dion. Perhaps you could unmute him, Kia, and then we can see if he perhaps has an answer for us as well.
Leon, we've allowed your mic. You can just unmute on your side.
Thank you. Can you hear me?
Yes, Dion, we can hear you. How are you?
Good, and you? Sorry,
Good.
I'm also from the electrical contracting industry. So two things. One is, if you've got a breakdown in where there's a gap in your agreement, the one thing that we must remember, although you cannot enforce the agreement on the company in the period that there's no agreement, what you must remember that those employment conditions at the workplace has not changed. So if the employer, say for argument's sake, you had a 5-year agreement, and that 5-year period he contributed, when the agreement lapses, doesn't mean he can stop contributing to the pension fund, because through practice he has now introduced those employment conditions into his workplace. So that solves the problem. The other way that at the bargaining council, that how we overcame the problem is normally your main collective agreement is published for anything between 1 and 3 years. So what we've done is we've published a separate pension and provident fund collective agreement that the department normally extends for quite a long period, normally for 5-6 years. That helps us when your main collective agreement lapses, that your pension fund contributions and the conditions around it continues in your industry, and that you can then enforce your pension fund contributions either to the pension or the provident fund. So that is one way of getting around the problem. The Department of Labour is open to assist in that manner. Thank you.
Thank you very much, Dion. I actually, I mean, that pension fund agreement that you spoke of could be a very good solution, especially because, you know, participation in a pension fund, for it to just be between 1 and 3 years could be extremely short.
Yeah.
And so if you have it for a longer period, it creates a lot more certainty for those members, and at least creates that longevity that you want in a pension fund or provident fund going forward. So thank you very much for that as well. I see Carmen's hand is up again. Carmen, you can go ahead with your comment or question.
Okay. Can I just continue here? I'm sitting with Dion. Just on the pension
yes,
fund
Mark.
agreement.
Yes, you can go ahead, Mark.
Agreement, yeah. Do you, as the FSCA, attach any significance to the existence of such a document? Because for us, it gets published by the Department of Labour. In terms of your interaction with us and your exercise of authority over us, is that document of any relevance to you? To the extent that it deals with pension fund matters, as per its name, it is a pension funds agreement. Do you consider it at all? Does it have any relevance for you? Have you encountered it anywhere else? We've got it, but the FSCA has never asked for it.
Yes. So I'm going to ask Gia to unmute Mr. Madumo, because he's more close to, and Silindile as well, actually. He's more close to in terms of registration. I know we don't ask for it when we do say on-site visits, but there has been an issue that was raised in the industry funds where there would be exemption that is applicable. And so there was an issue about how the FSCA shouldn't be registering participating employers where there is an agreement that says they should be registering as part of the industry fund. I'm just not close to that issue in terms of how it unfolded. So I'm just going to see whether Elvis would be able to assist and Silindile, because they deal with the rules on a daily basis. And anyone else from reviews and authorizations can always assist as well. Thank you, Elvis.
Okay, good morning. Thank you very much. Yeah, we do definitely consider such documents, especially when we considering the amendments or the rules or the consolidation, any of them, any form, because the reasons that give rise to such an amendment or will definitely might come as a result of these agreements. So we definitely, under those circumstances, consider that an agreement and see how best we can communicate and assist, or even go as far as approving such based on that. So we'll definitely ask for it if it's the reason that gives rise to an amendment or something.
Okay. So Mark, I hope that clarifies. I think in certain situations, any company documents or anything like that, as Alvis said, would have an impact on why the amendment is coming through, would be requested. And as I indicated, there are instances where if a fund or a participating employer is in a particular industry, and you can see it obviously from the special rules, because it is difficult for us to know whether an employer named Jupiter Sales, for instance, is actually in the electrical industry, right? And they would need to be registered in your fund. So perhaps as part of, if it's part of our registration process or in licensing a participating employer, we could look at whether we must include an industry reference, for special rules or not. But I think what's also difficult for bargaining councils is that we don't necessarily receive special rules because you're a type B umbrella. So, admitting participating employers becomes part of the fund's duties in terms of the collective agreement, and we might not always have sight of being able to put together the collective agreement with looking at those special rules. So as Alvis said, we'll probably only look at it when there's an amendment, but we don't have any jurisdiction over the agreement. It is just to make sure, as I understand it from Alvis, that it is just to match what is in the amendment is correlating with what is actually in that agreement for why you're saying you're making the amendment.
Correct.
Thank you. It might be a great idea that some relationship is established between yourselves as the FSCA and the Department of Employment and Labor, because they regulate whatever collective agreement we enter into, including collective agreement relating to the space that you are authorized to deal with. So that relationship, at some point, you would have to establish it, as I have seen, for example, recently with the Department of Education and Training, QCTO, and the Department of Labor, is that when various government departments have got elements of an industry that they have authority over, if there is no relationship between those departments around those subjects, it leads to unknowns for various departments, and therefore we are not able to pull collectively.
I think that's a very fair point, Mark, and I do believe it was raised as well in our previous webinar. And as you would have seen, we also pulled in the Department of Labor, the Deputy Registrar there to come in. But I think you're very correct in saying that we need to make sure that we've got a relationship where, especially where there shouldn't be misalignment, in your collective agreements or even in your sectoral determinations with what can be provided for in the rules of a fund or in the collective agreement in relation to the Pension Funds Act. So I think you make a very good point, and it is something that we definitely need to consider, and we appreciate you making the recommendation. Thank you very much. Gary Wilson, and then I think we'll then move on to the next presentation. Thank you.
Just in terms of the lapse of agreements in our instance, in consultation with the Department of Labor, we have now incorporated in terms of our term of the agreement a clause which says that the agreement will not lapse until replaced by a subsequent agreement, which means there's no cap anymore between any agreements. And that has helped us to ensure that no employer can stop contributions, or they can say that there's no conditions because the new agreement has not been extended. And the Department of Labor has assisted us greatly in ensuring that we incorporate such a clause in our agreements of onwards, even if the negotiations takes forever or takes longer than anticipated, there's no cap. The existing agreement remains in place until a new agreement is extended.
Thank you very much, Mr. Wilson. I think I've left one more question from Ronel, but we are on Mr. Wiese's time. And I want to thank Ronel again. I did have a question for you as well, but I'm going to leave it over to our Q&A session at the end. And I will just go back to your presentation in terms of asking the questions, and I think are applicable to the rest of the bargaining councils that are here as well. But thank you very much again for making the time and for giving us a presentation, very informative. And I think everybody should, especially in terms of knowledge and experience, please document everything that you have been working on for the longest time in your bargaining council, so that people that come after you, can also benefit from the knowledge that you've accumulated over the years. And thank you very, very much. I know from the discussion that we had with you, even in preparation for the webinar, just your passion and how you, spoke to us about what actually goes on in your industry. I must say, for me, it was quite a comfort as a regulator to know that there's someone like you that is saying, what we want to do is in the best interest of the members. And I'm sure that is the very reason why a lot of the bargaining councils as well are existing, to make sure that there are better benefits and better working conditions for members as well. So thank you very, very much, Ronel. I'm going to hand over to Mr. Wiese. He's from PwC. I think in terms of non-compliances that we receive on any contraventions, PwC definitely leads the pack. We had our meeting with IRBA, I think about 2 or 3 weeks ago, and we actually raised it again to say, some of the issues that you raise in your non-compliances that you give to us, we're quite sure would be applicable to any other fund, but for some reason, some of the auditors don't raise it. So we're going to raise that with IRBA as well. But you are very, very experienced, especially in retirement funds and on a wide range of issues. So we are very, very happy to have you here for the webinar. And I'm going to hand over to you, Mr. Wiese. Thank you so much.
Good morning. Thank you, Madam Chair. Thanks for the welcome. As you mentioned, I've been an auditor for over 25 years. I've been working on funds like Ronel since 97, so more than 20 years auditing both occupational retirement funds and also bargaining council funds and bargaining councils. I even audited some of these funds before they came under the Pensions Act in 2007, as Ronel has mentioned. I'm going to share, and hopefully you can see my screen here. Is that visible?
Yes,
Slides?
It is. Thank you.
Right. My briefing was really to recap for you, what does the regulator want? How do we account for contributions in a bargaining council fund now that it's under the Pensions Act? So it could be a bit from the accountant's point of view. They then asked me to really see what happens in practice, having listened to all the issues and problems and the uniqueness of the environment from the previous speakers. How do we deal with that in practice when we audit these bargaining councils? And then what is the impact really on the members in the fund? And how do we report on those matters, and having decided on what to do? So my agenda here is really what I've just went through. Quick recap on the Act. I think Ronel touched on it, but I just want to talk about the collection model again, and then look at the various issues and what the reporting impact is. So if I can kick off, what we have, the regulator published the regulatory reporting requirements for retirement funds in 2009. And really, it makes 2 specific references of how to deal with contributions. So under the definitions, they've added the definition of the accrual basis, and it starts off with an assumption. So under the accrual basis, the assumption is in the regulatory reporting requirement that you should use the accrual basis of accounting. And that means not on a cash basis or when cash is received. I'll show a practical example now what that means for those members attending who are not accountants. They make reference to the periods to which they relate. The previous speaker talked about the rules of the fund. The important thing here is it also makes reference, if I read that last bullet, past transactions involving the payment and receipt of cash, also obligations to pay cash in the future. In other words, what we have here is a debtor situation. In other words, any cash that we must receive in terms of the fund rules. And that implies an accrual basis. You have to raise a debtor that extended agreement and the fund rules prescribed for the participating employers in the books of the fund. There is a chapter on contributions in the regulatory reporting requirements, and on page 55, it's got a separate header on recognition and measurement. And here it's spelled out the same message. All contributions that you need to account for are those that were actually received, in other words, cash basis, or receivable. In other words, we have to accrue, we have to apply the rules. If the extended for each class of member prescribes a percentage contribution, you have to accrue for that based on his salary. And it specifically says that you have to create a contribution receivable debtor. And then it just says you have to split it between what goes towards the member and what goes towards the risks and other benefits. So really the RRR is very clear. It's got two areas where the regulator says you have to accrue, you cannot use the cash basis. So in practice, all this means is that for every fund and every employer, they have to contribute for 12 months for every member who worked. And there's an example of cash versus accrual. It's a simple example. If for 11 months, but they only paid, if a year's contribution 10,000 a month, your annual contribution expected is 120,000. So any amount that you got less in the books, it doesn't matter that you got in the bank. You have to show in your contribution line 120,000 and a debtor for the balance. Right, just some sections from the Act, just to before I talk about the issues. I think we've discussed the 7-day rule already. Previous speaker, I did note there section 25A. That's actually the section in the Act that allows a fund to apply for exemption. What we have seen in practice, quite a few funds get 20 days. So the 7-day rule gets extended to 20 days. Regulation 33, it says that there can't be a discrepancy between what the employer or the participating employer's contribution schedules indicate versus what is received in the bank statement. So if that amount every month is more than 2.5% different, it must be investigated and followed up with this particular employer. So this is a very onerous rule, because as you can imagine, 2.5% on the small or relatively medium-sized contributions for a high volume of employers could easily be exceeded. And then it means that you have to follow up 80% of your participants every month, and obviously the labor required and the cost. And I think Ronel mentioned that before, but I'll come to that in the next slide. The late paid interest that was mentioned, every fund must charge late paid interest in terms of 13A7 if somebody doesn't pay within the prescribed period, which, as the gentleman asked what that is, depending on your extension or exemption, it will be 7 days, but let's just assume it's 20 days. Anything after 20, you must now start charging that employer interest. And the interesting thing is it's calculated from the first day of the month following the month in which they were late. In other words, if you missed it this month, from the 1st of December, you will start calculating that interest until the date that it's actually in the bank. Just two slides here on the late paid interest, because people talk about it very flippantly, but there are some specific matters that a lot of funds and councils miss. The prescribed that the rate at which it is charged is prescribed from time to time by the minister in the Gazette. It's compound interest, so it's not simple interest, so it's interest on interest. The rate at the moment, depending on the amount outstanding, is between 16.3 and 19.3%, which is quite good given the markets. I was reflecting on this. You should encourage your employers to pay late almost. You can earn more from late paid interest if they are solvent than investing the money. But that's just tongue in the cheek. The interest that is not paid, the gentleman mentioned an employer that has 5 million outstanding. You compelled by Regulation 33 to charge interest on interest as well. So this debt could go out of control indefinitely. And the interest itself has a 2-month rule. You have to pay it not later than 2 months in respect of the month where you haven't paid it. So the normal contribution is from the first day from the month in which it was due, and the interest is another month later on top of it. So the systems and the admin required to calculate this interest, you can imagine, I won't go into it, but it can become very onerous with high volumes of employers, some owing less than 10,000, others more than 10, having to change the interest rate applicable, and so on. So that is just one complexity that I wanted to highlight by giving you this detail. There are, in terms of Regulation 33, other penalties that can be levied by funds in terms of the fund rules. In other words, you can write, the specific trustees can write a further penalty in addition to those prescribed by the regulator. So if you want to add another 5% interest on top, I guess it can go in the rules. Just more the accounting concept from the accountant's point of view, that this late paid interest must be accounted for as investment income of the fund now, because obviously that's the reason for it. The reasoning by the regulator is if you don't invest the money in time, it can't be invested in the market with an asset manager, and therefore the fund loses investment return. And therefore you must now, after 7 days, replenish that loss by paying interest. And the other concept that the regulator wants is that each member affected, in other words, the underlying members of that employer, must be put in the same position they would have been had the money been invested. So the argument here is the interest earned must be allocated to the member to whom it belongs. Okay, that's on late paid interest. I'm not sure if everybody's aware of all these rules. The collection model that I wanted to mention is really the fact that in practice we have 2 cases when we go out to audit these bargaining councils. We sometimes have the bargaining council in between as a self-administered bargaining council, collecting their own contributions and dealing with these participating employers, versus where you just employ an outside registered administrator, typically the bigger life companies and people like Alexander Forbes, Sanlam, Absa Consultants, and actually those persons. So the impact of that, why I put this here, because it complicates the life of the regulator and of the auditor, because now you're dealing with the council's bank account, collecting the contributions and then paying it over to the fund's bank account, which is sitting at the third-party administrator, versus if it was just the third-party administrator, all the money was easily controlled on one spot. The problem now is that you have the council as a receivable in the books of the retirement fund for contributions receivable on behalf of all the employers, and you don't see the names of the employers who are not contributing behind it. You also sit with the problem where the council collects money, it arrives in their bank account and they don't know which employer it belongs to, or they know which employer it is, but they haven't had the lists with the underlying members who contributed. So they can't allocate the money. So it's unallocated cash. And this is now off the books of the retirement fund because it's sitting at the bargaining council's office. So typically you have to pay over the money to the main administrator if you know which employer it belongs to. If you don't know which employer it is, this money will sit off books at the council, and the fund will not reflect that cash that was received. Something that Ronel didn't mention, but another practical aspect is if the council collects the money from the employers, the council has a pecking order, and there are many allocations to be made for each month's contribution. Typically, I've put in brackets the union subscriptions, medical subscriptions. A lot of these councils have clinics. You have to deduct the council levies, and of course the retirement fund. So if an employer falls behind and the money comes in, who gets the first allocation? That is a big issue at the councils. Do you pay the union first and then the retirement fund contributions that are in arrear, or do you take the council levies and just allocate that money to the long outstanding late paid interest and record the current month's retirement fund contributions as outstanding? So that is a big practical issue that happens on the council side. The other thing that happens is that if you have the situation where you have two administrators, the bargaining council office in between and the main administrator, you add a layer of cost, because you now have an office of staff and you have the council levy, which is, the question can be asked, is that beneficial? Is that the most cost effective way for the benefit of the members, or should we just like disallow it and say everybody needs a professional administrator? I don't want to step on toes. I'm just speculating and asking, stating the question here about the cost, because the councils typically present high volume, lower paid employees, and we're adding an extra layer of cost here by having this in between collection office in this collection model. What we often find as well is that the council who collects on behalf are in fact required to register as an administrator in terms of section 13B of the Act. The Act's very clear: no one shall collect contributions unless it's registered as an administrator, and for that there are various requirements, and you have to report on that annually. So we have found that when we audit the councils, that they are not registered and in transgressions of the Pensions Act. So that's all I wanted to say about the complexity of the collection model. If I can then move over to industry issues. So why I say those are issues, if I compare a bargaining council fund to a loose standing, what we call occupational fund, where you have the industry funds for out there for particular employers who contribute monthly. What we have in bargaining councils typically multiple employers. We're talking thousands of employers versus a standalone fund where you have only one employer, or maybe one with 4 subsidiaries, but you still have 1 or less than 10 pay points, whereas a bargaining council you have potentially thousands of pay points. The biggest issue is really the fact that it's weekly wages that we're talking about, and weekly contributions that are being earned versus monthly. It's much simpler to control a salary contract where there's a fixed monthly fee and a fixed monthly percentage to be deducted and paid over than a wage worker. First of all, they don't all work every week, and they don't all work every day of the week. You get paid per hour or per day. So your pay is not fixed like a monthly salary check. because of the number of employees that you typically find in the various industries, the volumes of transactions become immense with all the number of participating employers, the number of weeks, and the number of members. So that administration office, be it at the council or at the life insurer, has to staff up to deal with the volumes. And because of those regulations and rules where you have to reconcile the bank statement to these schedules, and remember I said there's a 2.5% difference allowed, otherwise you must follow up and reconcile. It's really difficult for in practice to get through the volumes in the allowed time. Now let's just assume it's 20 days before the next cycle starts, and you quickly run into a backlog. So the non-compliance that typically occurs because of the reasons we've discussed, and myself and the previous speakers, is not necessarily always non-payment of contributions. Obviously, that happens when you have a struggling employer. Somebody mentioned irregular project work. They don't always work, they don't always earn, so they can't always pay. You also have the late payment because of cash flow problems. I like the concept of a bucky employer. The bucky needs petrol, so we can't get to the next project, so we'll rather use the pay to fill the tank to get to the next project than to pay it over to a council. And now we have a late payment or no payment. The LPI is a complex calculation, and it's high volumes, so it's often not levied. And if it is levied, it is never settled because the poor employer is just struggling to make good on the previous contribution due, never mind the late paid interest. And you just end up in this vicious cycle of hundreds and thousands of reconciliations with differences and the delays running over from one month to the next. So what we find is that the bargaining council officers tell us it's not feasible for them to really comment or conclude on whether these contributions they're receiving are complete and accurate. They don't know whether every employee who worked in the week received whether the employer paid over contribution for that person, whether he was paid for 10 hours if he worked 14, whatever the schedule says, they have to believe. If Mr. Employer says I had 10 people on my building team this week, but he had 15 and held the other 5 pay contributions back to fill the bucky's petrol tank, you wouldn't know. And the previous speaker mentioned there are different rates of contribution depending on the agreement. You know, senior superintendent, junior shopkeeper. You could potentially use the lower rates. In other words, the job grade is misstated on those contribution schedules. And you have to trust the employer that these people are categorized right, so they're contributing 5% instead of 8%. But meanwhile, the guy is more senior and he is eligible for a higher contribution. So we end up with the administrator just relying on the employers blindly in many cases. And you have to accept what hits the bank statement. And you are struggling then to determine what that data should be, what the RRR is asking us to account for, the receivable from all my employers. If I don't know how many people work, if I don't know if they're the right grade and the right percentages applied, then I can't do the sum to raise that data. And the long and the short of all is this is that we are really accounting for contributions on a cash basis, and therefore contravening the regulatory reporting requirements, the definitions I started out with. The impact for the members, in other words, is that, I mean, my assets are growing on a cash basis. If you think of it, you are investing, the fund is investing all the contributions each month physically in the bank, but the member credits supposed to be growing on that expected contribution. So there's a total mismatch. And putting your auditor's hat on, the Act asks in Section 9 to consider member prejudice. Now, member prejudice means you cannot apply materiality. What is material for me is not material for the next guy. If I only earn 100 rands a month, 20 rand is material, because, whereas somebody earning 10,000 rand, 10 rand might not be material. But the Act says the auditor and the regulator must ignore materiality and say, okay, it's possible that not all members' contributions are paid over. The employers are not submitting necessarily complete and accurate information, and those who underpay or submit late, they're not even getting charged interest. Members will lose that as well. So we think, and by definition of Section 9, members are possibly prejudiced. So what do the councils do? First of all, they try to buy time by getting exemption and extension. I've written the 20 days there, we've discussed that. They change their accounting policy, in other words, to read in line with what happens in practice. A typical one we see is that the current month's receipts are regarded as the current month's contribution. That's just another way of saying we're applying the cash basis, not the accrual basis. We have seen that people keep record of that member record, what is theoretically due versus his actual cash in the bank. And when the person retires or leaves, they go to that employer and say, case by case, if you had contributed the last 6 months, you would have owed this much. This member credit we have on the books is 100, he needs 160, and they then get a once-off back pay or achterskot contribution from the employer. That's a practical way of negotiating, making sure that each member, at least, of that employer, when he leaves, gets his full benefit. It's a workaround. It's not defined in the law, but at least this is one of the practical things that you make sure that struggling employer does make good to his employee who is in arrears. We see that contributions, especially in the COVID time, was allocated to at least fund the risk benefits. Should an employee die, at least the family has the group life benefit, and then the balance gets given to the savings account. In other words, that was the practical solution. When there's a short contribution, make sure the risks are covered first, because they are regarded as more important by most trustees. We see that trustees are in practice disclosing the fact that they're not complying to the RRR and the law in the non-compliance section of the trustee report, and they're accepting the qualification by the auditor then, which opinion then also states the same facts. There's really nothing else you can do, because you either apply to the law or you don't, and then if you do your best, accept the qualification and disclose what you've done. The councils and the bargaining funds, I think Ronel mentioned this as well, have to focus on the larger employers, purely because the infrastructure is better, the communication is better, and the volume, the effort, the cost effort pays off better in dealing with them and getting the best result for your spend. There are compliance divisions or departments where you send out inspectors to employers. This is the only way that you can really go and interview those employees and check, did you work 4 weeks last month? Are you a supervisor or are you a steward? What is your rate? What does your payslip say? And ticking the boxes. So that works. Surprise inspections, very effective, but very labor intensive and expensive. Of course, in terms of the rules, the warning letters, the suspension from the fund, as previous speakers mentioned, that is the last resort, because you don't want to lose the members in the fund. The whole benefit of a fund is that you have a high volume of people together. There's benefits in numbers because you negotiate better risk premiums. It becomes cheaper to administer the more members you have. So you don't want to chase employers away unnecessarily, but if they really need to be handed to the police and they're totally crooked, I guess this is the last resort. Of course, you get the outsourcing to third-party debt collectors and handovers. Again, very expensive, and again, you should focus on there's a focus on high amounts. You wouldn't necessarily employ a lawyer for the bucky. You would employ it for the bigger industrial employer. They get deregistered eventually. That's after suspension, and then you're rid of them. Of course, a lot of other issues there. You're in the queue with other collectors trying to collect the arrear contributions. A big thing that we've seen in practice is that the late paid interest that you do collect, the amounts are small, the volumes are high. It really just gets allocated to general fund reserves. The actual affected members seldom get the interest case by case allocated to themselves, because the costs involved in going into each member record and splitting that is very cumbersome. And I don't think that, although late paid interest is a great concept, to allocate it to on a member level, we've seldom seen in practice. It really just goes into the bigger pot of the fund. First of all, because it's difficult to get from the employers, and second of all, because of the admin burden. I want to close off with the reporting impact. I mean, what happens now? I've just written down here the 4 types of reports that are required to the regulator. The audit opinion we've discussed in detail earlier is qualified on completeness and accuracy of contributions and late paid interest, basically. That is then also disclosed by the board in the board report. The whistleblowing section of the Act is section 9.4, asks the auditor to report any act that is not any section of the Act that is not complied with, and that in his view prejudices the member, and in most cases 13A, which is contribution, 14A and 14B are being transgressed, and members are being potentially prejudiced. So we write that letter together with the audit qualification. In terms of the Financial Sectors Act, you also have to report that to a different division of the FSCA in terms of section 252. So there are 3 places of reporting, and actually there's a 4th one. The principal officer has to mirror the member prejudice letter in terms of section 8. So you have 4 times the reporting, and I think that's what Madam Chair referred to. The funds that we audit, we tend to submit these letters to them. And lastly, you always have to consider a reportable irregularity. In the years that I've audited, we've seldom done that, because the definition of a reportable irregularity is that there's got to be gross negligence by the Board of Trustees. So if the board has done nothing, they haven't sent warning letters, they haven't sent out inspectors, they haven't employed at least one lawyer to go after one of the large employers, then you can't say that they've been grossly negligent. If they do nothing, then they'll be grossly negligent. Then you will have a reportable irregularity. Also, if there are obvious fraud, direct fraud, or misappropriation of funds, that's when you have a reportable irregularity. In practice, as I say, very seldom, never really a common report to issue. So the first 3 gets issued, reportable irregularity can be avoided. So my conclusion, Madam Chair, is it's very difficult to apply the Act, the requirements of the Pension Funds Act, as it stands in its current state in practice for bargaining councils. What the boards and the trustees are doing is, all they can do is they can do their best and demonstrate that they understand the issues and that they are doing their best to collect, have evidence in writing, service level agreements, visits to employers. They then disclose all of this. They accept the qualification by the auditors. One would expect there should always be a qualification on accuracy and completeness of contributions, and avoiding to be named and shamed in a reportable irregularity report. So in our mind, if you don't have a RI issued on your set of accounts, the fund is relatively successfully managed in terms of on a cash basis, in terms of accuracy and completeness of contributions. That is my story, Madam Chair. I don't know if there are any specific questions.
Yes, I see there is a question from Mr. Assad. I believe he's from the motor industry, if I'm not mistaken. Kia, please could you unmute him? And in the meantime, I just want to start by saying thank you for the presentation, and then we can take the questions as well. Or Kia, did you want to ask a question as well? Sorry.
Yes, I wanted to ask a question. Thank you very much for such an insightful presentation, Verwey. Yeah, I think for me, from a regulator's side, it's given a lot of things to think about. So thank you very much for such an insightful presentation. I just had a question on the agterskot contribution. I just wanted to find out, in your experience, is the interest then backdated to, to when the last contribution was received and stuff for the member, that is?
Yes. So the calculation is done by the council, by the administrator, saying that Mr. A, you last contributed at this point. You owed him this percent, and here's the interest on interest. Here is the calculation. You owe us this. This is what he theoretically should get. Sometimes the full amount isn't paid, but what they do achieve is get a bigger benefit. In that sense, the member was, in other words, enhanced his member credit. And we've seen that. This I've seen with municipalities. Municipalities are often acceptable to this type of arrangement.
All right. Thank you very much.
If you could unmute Mr. Assad, and then we'll have Mr. Omagiri after that. Thank you.
Hi. Good morning, everyone. Thank you very much. That's a really, really great presentation. Thanks to the FSCA for inviting you and, and just for highlighting the type of problems we face. So, at the motor industry retirement funds, just to give a scale of what we're dealing with. I mean, we have 240,000 members and we have 24,000 employers. I mean, that is the scale of what we are looking at. And I mean, conceptually, if we take away what the law says and just look at it logically and conceptually, is the cash basis not the correct way to account for contributions for industry funds? I mean, all we're doing in trying to do this on a accrual basis, and we're having discussions with our auditors at the moment, is, you're just doing accounting gymnastics, but at the end of the day, the cash that you received is what you can credit the member. I mean, does accrual basis make sense in this environment? If you just look at it logically, I mean, what is your view on that?
Thank you, Adam. The fund rules and the extended bargaining council agreement is in effect a contract. So you have to accrue or pay in terms of a contract. If you rent a premises for 50,000 a month, you cannot say I pay over 40,000 for it, the other 10, don't raise a debtor for me. Contractually, you need to continue accruing what's due to the member at his percentage of his salary until the day that fund rules expire, and they can only expire when that employer is liquidated or deregistered. So even if he's not operational for the last 3 months of his business before he gets due, even that last 3 months, you have to accrue so that when you go to the liquidator, you can claim those last 3 months, even though the guy wasn't operational and not working or dealing in his normal business. That I'm not a lawyer, but that's how I've been explained the law works. That contribution contract can only be nullified and stopped once that employer is physically liquidated.
Sorry, Takalani, if I may call you, can you give me a bit more leeway if I can ask another question, if I may?
Oh, no, definitely, yes. Please go ahead.
Okay. So I think, Verwey, the issue is that, I mean, we have a DRC, a dispute record resolution center. I mean, you have a summons against an employer and you go there, the summons get issued and there's nothing to collect. Now what do I do with that data? I mean, or the guy's liquidated, as you pointed out, or he's left the country, or he's done a whole lot of things. I mean, theoretically, you're sitting with this data, and for how long do you continue with that data? And whose money do I use to keep on pursuing? At some point, I mean, even the major credit retailers, at some point, they write off a debt because, you just can't collect it. Now, in this industry, we still haven't come to terms with that to say, when is it that we can't collect the money and what do we do then? Do you have any views on that?
Yes, I agree with you. The Act doesn't allow for a contribution to be impaired or written off. So unless the Pensions Act is altered or changed to say under what conditions the contribution that's supposed to accrue or that did accrue can be impaired. Auditors talk about impairment. Fancy word for writing it off. We are not allowed to impair a contribution. That's why if you look at the financial statements, the prescribed financial statements, there's a contribution receivable. And there's a specific procedure to go and inspect when was this collected, and you have to report on it. But maybe the regulator can give clarity or give guidance as to at what point will they allow you to write it off. But we audit funds and you have contributions outstanding for years. It just gets carried over, opening balance, closing balance, it's sitting in there, and we check the aging. Obviously some of it gets collected, but you're sitting here with the opposite of the unclaimed benefits. The pot that's growing, this one can also grow and potentially can never write it off.
I mean, on our funds, we've just done a calculation. Once an amount is earned for over 90 days, you only collect 3% of it. So are you saying on the funds that you audit, you don't even create a provision for doubtful debts? Do you just accrue the full amount and you create no provision for doubtful debts? Or do you create do you ask the fund, does the fund have to create a provision for doubtful debts?
If it's under the Pension Funds Act, we don't provide, there's no provision for doubtful debts. You can never write off or provide against a contribution unless the law is changed to allow that.
And then would you support the debate that nobody wants to answer this hard question in the law, right? So they say, go to the police, go to the NPA, but really nothing happens, right? And you're creating an admin burden on an admin burden. I mean, should we not have the debate to say, what happens with, at a certain point when you followed all these procedures and you still can't collect the money, then what? Nobody wants to, everyone's terrified of that debate, right?
Yeah, look, what I would try and do, I'm a trustee myself, but we don't have a collection issue. Change the rules and say this is what happens if we can't get it in, and see if you can get the rule approved. If the FSCA approves the rule to provide after 90 days and write it off, then you're fine, because then you're administering your fund in terms of the fund rules. Because the Act is clear that the rules, if you're uncertain, go to the rules. So the key here is, will the regulator approve that rule? If they approve that rule, I think we're fine.
And then if they don't approve the rule, then that's the time to take a stand.
Yes.
You can take a stand, but the auditor must report that then.
No, I understand, but I mean, you can put in the rule amendment and then challenge the FSA as to why they don't want to approve that rule amendment, right? I mean, that would be the correct procedural way to do it without, engaging in open warfare, right?
Can I suggest perhaps a better way of us avoiding the warfare? Is that perhaps, I think it was raised, especially in the previous webinar as well, about the costs. And I've personally had a few questions around when do you write it off, even as was already mentioned in the presentation, even in relation to collecting some of the interest. Some funds are saying, look, we're actually going to incur more money in collecting the interest than what the interest amount is, right? Because then every month it's about 10 Rand or something that's outstanding. And I support Ronel's suggestion that bargaining councils need to come together. And perhaps for this issue, it's not really only bargaining councils, it's also just industry saying, these are the issues that we're facing, we're trying to recover. Here are our suggested, I want to say, solutions for what can be done, because we don't necessarily see practically, the challenges that you face, especially, when it's different sectors and their different experiences. But, so give us a business case to consider, because as Mr. Wiese has already said, you could actually then get a law changed, especially with provisions like prescription that we discussed at the previous webinar as well, that it might become impossible for the fund to even recover the monies. And what do we do? And then, we have that discussion first and to see what can be done, because what you're raising is really practical issues that you're facing, that everybody's facing, that you can't do anything about. And the fund needs clarity and industry needs clarity on it. So let's have a discussion around it. Give us a business case. Let's see, even together with the auditors and everybody else that's having this experience, what is it that we could try and write into policy, and take it from there. Let's start with a more collaborative approach than us rejecting rules, because that also is dependent on, it's sitting there, then we go for legal opinions. It might actually be more long drawn out than us just first starting with a conversation, and then for us to even get a legal opinion on our side as well to see what can be done.
So sorry, Takalani, so which is the department would be the best to engage with? And, just because there's practical problems and we have to find practical answers.
Yes. I think please send it through to Colliers department, which is under ours as well. And then we will make sure that we get together the relevant people. So, regulatory framework, reviews and authorizations, and also in terms of policy discussions, we could even then also make sure that Treasury is there for your discussion as well. So I know Collier is brilliant at that, bringing all the parties together. So I would definitely say, please send it through to her so that we can start with some of these practical discussions. The webinars were aimed at that. And as I indicated, even in the previous one, was that there'd be a lot more, even on unclaimed benefits and other practical issues that funds are facing that we need to undo. But, a webinar might not be the best place, but it starts the conversation. So please, we need to resolve these things for the betterment of the governance of the funds and also for the members as well. Because you can't just keep chasing money that you're not going to get, but you keep keeping it on your books. And that's a practical concern that we all can't do anything about. So please send it through to Collier so we can start the conversation.
Yeah. Okay, so I think I've taken enough time of colleagues. Thanks. It's a really great presentation, something that we face every day. So, thanks to the FSA for thank you. I hope I'm pronouncing your name correctly. That was a great presentation. You've obviously been doing this a long time, so
yeah.
appreciate all your input.
Thank you. Kia, if you could unmute Mr. Giri as well, Omar.
I have unmuted him, Taki, but just before he responds or asks a question, I just wanted to possibly add onto what you were just saying now about the funds approaching the FSCA. And I think you can help me as well. I think the reporting regulatory requirements as a conduct standard has been drafted, and I think it was sent out for comment because I did see that they've kept the accrual basis again in the new requirements. So I think funds can also take that opportunity to add comments to say, practically this is not working. That's also another avenue I think they can explore so that at least we have a base to say the funds have been raising it. It's there in the response to the new reporting requirements, and then as well when they approach the Conduct Supervision Department as well.
Thank you very much, Kia. Yes, I think that's a wonderful idea. I think what we can do is possibly for those people that might not have the draft already available, perhaps we could send it to everybody that's on the call, just so they can see what is proposed and then for them to be able to see the procedures or even just the link on our website for the consultation. But I think that's a wonderful idea, because then we have to give you a formal response, Mr. Esad. So we would, in terms of your comments, we'd have to come back to you to say this is our response. And that's a great way to start the engagement as well. Thank you, Kia.
So Takalani, when you call me Mr. Esad, I keep on looking around for my dad, and he's deceased like 20 years. So I thought, has he come back or what, Call me Adam,
okay,
please.
No. Adam, I think that's a wonderful suggestion from Kia, and we can definitely take it from there. Thank you.
Cool. Thanks a lot.
Hi, good morning. Thank you very much. I thought I was in the queue for 100 people, but nevertheless, thanks. Can you hear me? Hello?
Yes, we can hear you, Omar.
The first thing I want to say is that I don't agree, right? The first thing is that these members in the bargaining council pay to these councils. These council officials come with excuses to say they can't collect the money, but those workers, and every worker in the metal industry pays a fee to the bargaining council, and the purpose of that fee is for them to manage, to monitor this agreement and to do their work. No, why are the members paying these fees? If you talk about treating customers fairly, it would start here with the bargaining council treating these members fairly. Go and do their work and make sure they collect this money from these employers. It must be assumed that every employer would not paying the money has stolen the money. How can it be assumed that every employer that's not paying is struggling? Because at the bargaining council, there's various avenues for employers to go through if they're struggling, there's short time, there's layoffs, and they don't have to pay the monies at the time. Maybe just pay the insurances for deaths and stuff like that. But there is so much for them to go to the bargaining council to say that we're struggling, we cannot maintain these workers, we lay them off for 6 months, 3 months, 4 months, whatever the times. Then they don't pay. It comes to the MIFA. We as a fund look at this employee is not paying, we phone him, we ask him why he's not paying, he refuses to pay, we then hand him over to the bargaining council. Again, at that stage, he can make an arrangement to make sure that they take into his difficulty and then pay off the debt. He doesn't do that. They take him to the CCMA, whatever they do there, he doesn't do that. He maybe signs something and he still doesn't do it. We then take the lawyers and go after him. And we then go after their personal assets. And then we do get the money from them. We've collected AUDs for about 1 billion. We've collected cash, 700,000, since the inception of this law. So, no, in that process that we are following, even the lawyers, our lawyers, when they go after them, they speak to them and say to them, guys, you've not been paying, you're not paying. What is the problem? Then they will say, no, we're struggling. Then they make an arrangement for them to pay that money off over time. So there's no need for us to come here and make excuses. Each of us must do our job. These poor workers, it's poor workers' money. How they, these people that's talking here, Takalani, has never worked in the factory. That's the problem. They rich. They have food on the table every day. These poor workers in this industries don't even have food on the table. Can't even send their children to school. But these monies are deducted from their salaries for their pensions. And yet, we can't look after these poor workers. We come here with excuses to say that these guys are struggling, they can't get the order. The council allows them for that. If they're running short, they can't get, they go to the council, they ask for exemption, we don't, and the council allows it. There's no need for them to deduct monies from work. Usually, what I find difficult, I'm so angry that when some other people steal, they find a way to color it in with another color. But when a black guy steals one toilet roll in a factory, I'm a shop steward, I dependent workers. One toilet roll, he's fired. They don't tell him return the toilet roll. They don't tell him bring it back in pieces. One toilet, they take the toilet to security, here's the toilet roll, the guy stole, fired.
Yeah.
Why?
Omar,
no,
Omar, I think one of the things that we definitely, and I'm sorry to interrupt you, one of the things that we discussed specifically at the previous webinar as well was we must, find efficient, effective ways for us to recover the monies as soon as possible. I don't think that is something that, is not understood by everybody. I think, unfortunately, there are circumstances where, you will get that exception, where someone just packs up and leaves. And right now, obviously, we don't want that to be in the majority of the cases, but if it does happen, what can we do?
But when somebody packs up and leaves, shouldn't we go after the directors? That's what your law allows. We can
Yes.
go after, they can pack up and leave, but we still go after the people who own the company. We can still go get their houses. We can still go after them. Why can't we go after them?
Yes. No, I think we definitely can do that, Omar.
If we can't find them, if they're not more in the country, then it's fine. But usually what they do, they just start another company under another name, and we will find them because the unions know, most of the unions know these guys. When they open the company, they will know the guys open the company around the corner.
So, Omar, I think you've definitely made your point. And you remember when we were saying that we would have these discussions, I think it's part and parcel of you also, as a fund, also being around the table with the other bargaining councils and us seeing what is working for you.
I'm listening to this webinar, and when you're going to allow people to get away and get exemptions because they don't want to do their work, then I have a problem. People must do their work. They must go after this. If all these guys who complained in this meeting have gone after these employees, can't get them, right, didn't recover the money. I can understand, but you just go to the bargaining council and says after the bargaining council, no, we're writing this money off.
Yeah.
We don't do, how are you supposed to monitor them to make sure that we treat the customers fairly? I can do the same. We're just going to use the bargaining council. They're bloody useless in any case. We will just.
Yeah, I don't think it was an outright, we're going to give them an exemption. It was, please give us your business case so we can start the collaboration and the talks. But it wasn't necessarily that that's going to happen. So Omar, we do have to have facts on the table. We do need to know what the different options are. But I think you've definitely made your point, and we're well into our break time. I'm just going to allow Marilyn to also give us her comment. Or her question, and then we will start our break. Marilyn?
Hi, thank you very much, and thank you again for the excellent presentations we're having. I just wanted to raise a point which hasn't been raised about the induplim rule that I believe is now applicable to contributions. I didn't see it in the old section of the Act or regulations, and I don't think I've seen it in the new proposed Regulation 13 changes, Section 13 changes that are coming in regarding the collection of contributions. So I think that the FSCA has now confirmed that the induplim rule does apply. For those who don't know what that is to limit the debt to the total outstanding amount that is due, so that it doesn't exceed that particular amount. So I just want to get clarity again on that from hopefully Takalani or somebody who knows. And then secondly, I've seen a couple of questions come up about the fact that contributions are prescribed after a 3-year period. I don't believe that's true. If that is true, can somebody just confirm that? Thank you very much.
Thank you, Marilyn. I'm going to start with the question around the prescription. I don't think it was, we definitely had it at the previous presentation, and we had it from the presentation from Naheem Essop of the Pension Fund Adjudicator's Office. It's not a straightforward, it will prescribe after 3 years, because prescription on its own has got, when do you actually start counting the years? What is it that might be an intervening period and all of that? So it's actually not as just straightforward as saying 3 years and it would have prescribed. So, he has given us his presentation. I think in terms of the recordings and everything else, we can definitely then make that available, because it was a very detailed presentation. And what was offered there is, even in terms of legal opinions and cases that have been dealt with by the courts, and whether the FST has also dealt with it. You will see that it is on a case-by-case basis, and that's why I'm saying in terms of applying it straightforward, it's not just to say it is 3 years and therefore it will have prescribed. It depends on when you communicated with the members, whether the trustees actually started any action. So you really need to look at it from a case-by-case basis, applying some of those provisions from the cases as well as from the rule itself. Or from prescription itself. In terms of the induplim rule that you spoke about earlier, it was actually only in the draft conduct standard. It did not make its way into the final conduct standard. So it does not talk to, and I'm actually looking at the conduct standard now, the final one. I know we had put in initially a comment about the principal debt not exceeding the interest, but then there was an issue about what would you consider as principal debt? Would it include the attorney's fees? Would it include the interest and all of that? And we actually did take it out. So at the moment, it's not actually applicable in terms of the retirement funds at the moment, according to the conduct standard as it is now.
Okay, just there's a lot of confusion then, so I'm suggesting that the FSCA does put out a note, because we've been given confirmation from the FSCA that it actually does apply. So I think a note needs to just go out to the industry to be very certain of this. People have been applying it apparently for years, and others not. So think it is something that needs to be very clearly identified and confirmed. We didn't apply it before, and we've now got a particular case that we are applying it to, and we've communicated that to the client. So it is confusing. So if we could just get something that can confirm that once and for all. Thank you.
I will definitely do that for you, Marilyn. And as I said, I know that it did make its way initially into the draft one. And so, you know, what was commented on and what people saw would have been this discussion about the principal debt amount. But right now, as it stands in the final one, it wasn't included. Carmen, I'm hoping you'll allow us to go on a break first before we take your question. And from our side, I have my timekeeper, Keabetswe, who's going to tell us whether we're still going to take the allowable period that we put in, which was 30 minutes, or whether we take a shorter period. And I don't know whether we should make it rather 20 minutes so that we can just cover some ground. But really, after the break, it's only Gia's presentation. And I've prepared just a short presentation on just trying to compare the different provisions in terms of the late payment interest as it was debated at the last webinar that we had, just so I can show you where we are, and then you can at least also have that as part of the presentation and the webinar that we're having. So Gia, what time would you like us to be back from the break?
Oh, all that pressure, hey, Taki. It's currently 11:20. May I request that we break for 15 minutes and come back at 11:35. Yeah, the sessions after the break won't be too long. I think we should be done by just after 12, I think, or 12:30-ish. We should be done.
Okay. Thank you very much. Then we will see everybody back at 25 to 12, and then we'll just promptly get started with Gia's presentation, and then I'll just take probably 5 minutes to go through my presentation on the late payment interest. Thank you very much. Please enjoy your leg stretch and maybe make a coffee or get some water, and then we'll see you back here at 25 to. Thank you. Afternoon, everybody. If I could just get a show of hands on whether we are back in the room, and then I will hand over to Gia just to take us through her presentation on the conduct standard. Thank you so much. I see quite a few people are already back. Okay, thank you. Okay, Gia, would you like to share your presentation, please? And you could get started. Gia is part of the Conduct Supervision, Retirement Funds Conduct Supervision Department. And she has been organizing the webinars, especially for the Bargaining Council one as well, and the Municipal Funds one. She is a specialist analyst in our department and has previously worked in the Section 14 department as well. And yeah, I will hand over to her to do the presentation for you. Thank you.
Thank you very much, Takalani. Can you guys see my presentation?
Yes, we can, Gia.
All right. Afternoon or good morning, rather, everyone. So I'll just be doing a presentation on the Conduct Standard 1 of 2022, and that is the requirements related to the payment of pension fund contributions. I just wanted to state, though, before I get into the meaty parts of the presentation, is that this is not going to be an in-depth presentation of the conduct standard, but really an overview of the differences between the conduct standard and Regulation 33. So just to give a brief background on Regulation 33, which is the old regime, is that the regulation came into effect on 6 April 2001, and it was really introduced to lay down specific criteria for the provision of minimum information by an employer to a fund in terms of the payment of contributions, as well as set out the reporting procedures for instances of non-compliance with Section 13A of the Act, just to be brief. And really the conduct standards for the new regime builds on that. So the conduct standard was published by the authority on 19 August 2022. And this is the standard that will replace Regulation 33, as I've previously mentioned. And as a result, Regulation 33 has been repealed. The conduct standard will come into effect 6 months after publication date, unless otherwise communicated by the authority. At the moment, I think we're then looking at sometime in the middle of January. So I do hope that preparations for all of that have been coming along quite smoothly. And if there've been difficulties with the funds trying to, maybe change systems and stuff and so forth, if there've been any difficulties, it would be really nice to hear from funds or administrators what those difficulties would have been. All right, so in supervising compliance with Regulation 33, the authority identified that there was a need to standardize the manner and format of reporting by retirement funds, and that where retirement funds outsource the function of the function of recovering outstanding contributions from an employer that was outsourced to an attorney or third party, various issues needed to be addressed, and I will elaborate further on those later on in the in the presentation. And then the last thing that was identified was the drafting improvements that could be clarified the drafting improvements that could be clarified that were contained in Regulation 33. So all these identified issues have now been provided for in the conduct standard. With regards to the last bullet point on the prescribed forms, you would have noticed that these have actually been published. They were published on the 30th of September as a notice. Really, it's a determination, but they were published as notice 14 of 2022. And you may ask, why have these been published separate from the conduct standard? And that is because the authority was of the view that the forms will be issued as a separate document. And the reason was that practically, this would allow the authority to make amendments to the forms without having to go through the extensive process of a conduct standard. So the forms have since been published. So on to the key differences between the conduct standard and Regulation 33. I have just outlined what's really different, and that is the definitions that have been added, the notification to employers, communication, prescribed formats, late payment interest, and I think Takalani will also touch on that in her presentation, and as well as the new guy in town, which is the outsourcing of the recovery of area contributions. So now I'll just go into a little bit of detail on each of the key differences. With regards to the definitions, I'd just like to mention the following that stand out. That stand out. We have defined monitoring person. You will note that the conduct standard often refers to the principal officer or the monitoring person. And also writing has been defined, and this is particularly important because when funds communicate with affected members or all members of an employer, and they inform them of the employer's non-compliance with Section 13A. It has been defined as communication by any appropriate electronic medium that is accurately and readily reducible to written or printed forms. Funds must ensure that whatever form of communication method they use, it must be appropriate and effective, and that what is being communicated is comprehensive, concise, and is in a language that is easily understandable. I think then, for example, with the Bargaining Council and industry funds that we had spoken to in preparation for these webinars, I found it quite interesting that a lot of them used SMSs, especially to communicate Section 13A contraventions. And the SMS was very brief, to the point, put the message across to the member, and if the member had any questions, they could contact whoever at the fund. So that's really was quite pleasing to see. On to the notification to employers. You would have noticed that the standard requires that retirement funds inform employers of the duties and their duties and obligations in terms of Section 13A of the Act in the prescribed format. So employers must be notified before they start participating in the fund, and at least like once a year after starting participation. And you would have noticed in the determination that the notification also included the request to the employer to inform the fund of the person who would be personally liable for the payment of outstanding contributions. So in that form of notification to employers, I think it was paragraph 8, and that's or paragraph 7. It requests the employer to identify the person who would be personally liable. So I think that's also one of the new additions from Regulation 38 into the conduct standard. In terms of minimum information, in the contribution statements, the information that was required to be provided by employers in Regulation 33 really remains. We have then added the following in the standard that is to be provided by employers. So we have, before I get into the static data that's required, I just want to state that the initial contribution statement now needs to include the person the identity of the person who would be personally responsible for arrear contributions as required by Section 13A8. And the statement must also include a declaration by the employer that all the employees eligible to be members of the fund are accurately reflected. And in the subsequent contribution statement, it's really the same. So the declaration by the employer must be in the subsequent contribution statement. And then if the the responsible person in terms of Section 13.8 has changed from the initial contribution statement, then you will include the details of the new person in the subsequent contribution statement. Now we move on to the different, like the static data for each member. So you would have noticed in the initial contribution statement,
Kia, we've lost sound on our side for everybody. I also can't hear you. Yeah. Maybe she would just need to restart a little bit, and then we can get back. Apologies for the break. Okay.
hello?
Yes, your sound is back. We can now hear you, but the presentation is now not showing anymore.
Okay. Let me just... Is it visible now?
Yes, it is, Kia. Thank you.
All right, sorry about that. My connection, my line just dropped. So, as I was saying, in this first block, you'll see the new fields that have been provided for in the initial contributions have been highlighted in red. So that would be that the identity number or passport number needs to be separate from an employer pay or industry number. So Regulation 33 had said identity number or industry number or employer pay number. So now those are two different fields. And then we have the income tax number that's now required, contact number, email address where applicable, and the postal address and residential address. So that's the minimum information that's now required in the initial contribution statement. Then in the subsequent contribution statement, it would be that once the member has been loaded onto the system administration system or whatever system the the administrator uses, the fund uses, membership number would be created for the member, and this must now also be included in subsequent contribution statements. And with regards to minimum information, I know that you know, employers in this sector or in the bargaining council industry fund space aren't you know, don't necessarily give information as we would have requested it here. In consultation with funds that we spoke to in preparing for these webinars, as they were presenting their issues, you know, I just thought that maybe the authority could also consider possibly a prescribed format of minimum information to say this is how it must look. So we've now said, you know, this is the minimum information. Maybe it might be easier if we just prescribe a format of the contribution statement, and that is something that funds can then give to employers, maybe to make it easier for them to give you the information. You know, I don't know, that can be an item for discussion as well. So we move on to the reporting. On the reporting front, really, much of it pretty much remains the same. The only change really are the timeframes in which to report and the format. So you would have seen here, I've tried to do sort of like a time frame. So it will say within 7 or 15 days, the relevant item needs to be done. So either payment must be received or the contribution statement must be received by the fund. And obviously this will differ if the fund has an exemption from section 13A3 to say you can pay, the employer can pay in 30 days, 14 days, whichever the date is provided for in the exemption certificate. Then from that date, the rest of the time periods will follow. So in this instance, it's just a standard 7-day period and 15-day period. So employers have 7 days to pay over contributions and 15 days to submit the contribution statement. The standard then says the responsible person who checks for contributions who checks that contributions have been paid over and the contribution has been submitted in the 15 days thereof, reports any non-compliances with section 813A to the principal officer, and that's within 15 days, or the monitoring person. And this is in the format that will be determined by the fund together with their administrator or the bargaining council. Once the principal officer or monitoring person of the fund has been notified, they have 7 days to report to the board. And then once the board has been informed of the section 13A contributions, they must, 1, ensure that affected members or members of the employer, if they can't identify affected members, are informed of the contravention in writing within 30 days. So that is, the board must inform members within 30 days, and they must also report to the authority within that 13-day period in the prescribed format. All right. Should this timeline just carries on. Should the contraventions continue for a period of 90 days, then the board must follow the process of communicating to members within 14 days of the expiry of the 90-day period. The board must also then, within 14 days of that period, report the matter to the South African Police Service in the prescribed format. You will see that the format that we have published really tries to take into consideration all this information that the police might require when they're dealing with this matter. And then they must, yes, so they report to to the SAPs, and then they must inform members of actions taken in that 14-day period after the 90 days. And informing members must also be in writing. So the difference really here is that Regulation 33 had stated that funds must report to the Attorney General and had not provided by when the reporting should happen. So this has now been provided for in the conduct standard. And we do take note that funds do have difficulties when reporting to SAPs or dealing with the NPA. I think the authority will also take steps just to ensure that, or see if members of SAPs cannot be trained, maybe have a person that can assist with retirement fund issues, whether it's at SAPs or at the NPA, just to make this process a lot easier for the funds that we regulate. On interest on late payments, and I hope this doesn't touch on Takalani's presentation. I also tried to provide clarity following from last week's confusion or session, where we spoke on interest on late payment, and maybe people might have left that session a bit confused. Just to start off, late payment interest is now prescribed to be the prime rate plus 2%. So Mr. Wiese had said, I think it's between 16% and 19% per Regulation 33. So now in the conduct standard, it's prescribed to be prime rate plus 2%. And the difference really between what the conduct standard is now saying and what Regulation 33 said is that Regulation 33 said interest on late payments will be calculated from the first day of the following month following the expiration of the period in which contributions were payable. That's Regulation 33. And the conduct standard now says calculated from the first day following the expiration of the period in which contributions were payable. So the difference here is that Section 13A, subsection 7 in the Act actually says interest on late payments is calculated from the first day following the expiration of the period in which contributions were payable. So from this slide, I hope you can see that there was an inconsistency between what legislation was saying in Section 13A, subsection 7, what Regulation 33 stated. And we have now corrected that in the conduct standard to make the calculation the same as what Section 13A 7 states. So I hope that has provided some clarity, but I'm sure we can expand further on this once I'm done with this presentation and after Takalani's presentation. And lastly, I had alluded earlier to the fact that there was a need to find out various issues that the authority had picked up in supervising compliance with Regulation 33 with regards to the practice of outsourcing of the recovery of outstanding contributions to service providers, and in most cases, it's attorneys really. One, it was the issue surrounding recovered amounts remaining in the attorney's trust accounts for unspecified periods, resulting in those attorneys earning interest on the recovered monies and not transferring the recovered monies timelessly. That's the first issue. The second issue was the issue of conflict of interest. When appointing such attorneys and the exorbitant fees that were agreed upon then. And lastly, was really the matter of the board's lack of instruction and clear processes to be followed in the event of certain things happening, So once the monies have been collected, what must happen, or where employers do not cooperate with attorneys, what must happen. That was not really provided for, perhaps in agreements between the fund and the third party. So following from identifying these issues, the authority thought that there was a need to set out the minimum requirements for boards when they take the decision to outsource this function in order to minimize any undesirable practices that had come to the authority's attention. And in doing so, the standard says that boards outsource this function, then attention must be given to any conflict of interest, and boards should make sure that conflicts of interest are then avoided, you know. So that is basically that on conflict of interest. And I suppose that would just go with any other rendering or outsourcing of any other service, that boards should always ensure that a conflict of interest is avoided. And if there is a conflict of interest, it is noted. With regards to the fees that are to be agreed upon by the parties, boards must ensure that fees are commensurate and that they do not hinder the fair outcomes of members of the fund and the fund itself. And I suppose the question then will be, what is fair, you know? And well, in this instance, the authority does not regulate fees in this regard, but I think it would be really important for funds and the boards to consider remuneration principles in the context of treating customers fairly, which at the least, they require that fees should be reasonable and that the board must ensure that fees are reasonable. The conduct standard then provides for minimum agreements between an attorney or another third party and the fund. So at minimum, you know, the agreement should include that any recovered monies must be paid to the fund within 7 days of receipt by the attorney. The fee structure must be stipulated. The reporting frequency by the provider to the board must be stipulated. The timelines to be followed by the service provider in the recovery of contributions must be stipulated. The agreement must also state what happens in the event that the employer does not pay on demand. But I suppose the board should also give regard to what the rules say in relation to the employer's participation in the fund. So in terms of outsourcing this function, right, I think boards must give careful consideration to the fact that where a contravention of Section 13A occurs for more than 90 days, what does this mean for the timeline to be followed by the attorney in the recovery of the contributions? Because remember, Regulation 33 had not prescribed the period in which to report the contravention. So boards would have to think about a potential overlap occurring there, as you might have two processes happening at once. I hope that kind of made sense. Yes, so that was basically it on the key differences of the between the conduct standard and Regulation 33. But just to wrap up, really, there will be an impact, obviously, on the implementation of the standards on retirement funds. So firstly, the authority accepts that there will be changes required to systems used and processes followed by funds and their administrators in implementing the standard. In the consultation report that was published together with the conduct standard, there were some commentators that had said that there would be additional costs and improvements required to the IT systems used, but were never provided with quantitative data to that extent, but just that there will be costs associated. And whilst that is true, the authority is of the view that although the implementation may result in an additional cost, those costs will not be recurring costs, and there is also no indication that these additional costs will have significant adverse implications. The authority is therefore of the view that the envisaged additional costs are justified, taking into account the expected positive outcomes that will be achieved through the implementation of the conduct standard. Thank you. That is all from my side. Are there any questions?
Yeah, I was just responding to Marilyn's question in the chat. She has asked, is the new calculation for the late payment interest already applicable? And has Regulation 33 been withdrawn? So Marilyn, Regulation 33, especially in respect of the late payment interest, the section or Regulation 33 wasn't actually accurate in terms of reflecting what is required in terms of the regulation, in terms of the Act. And so on that particular instance, I mean, the sooner we can get back to what is required in terms of the Act at the moment, the better, because, you know, I must say especially if you consider the debate that we had last week, there was definitely inconsistencies or different interpretations for that matter. And, you know, the regulation didn't help in clarifying which way it was meant to actually be done. So the sooner we can start calculating it in respect of the provisions in terms of the Act, the better. The Regulation 33 has been withdrawn, but the conduct standard is only applicable from February because there's a 6-month implementation period. But like I said, the sooner you can start with implementing it the way that it's supposed to be in terms of the Act, because it's aligned with the conduct standard, the better, since the regulation actually would have been correct in terms of reflecting what the Act provided for.
Thank you very much. So in other words, the calculation should still be done on the old calculation, not on the prime plus 2 at this stage.
Definitely, in terms of the amount, in any event, yes, the interest one, that definitely not. I was referring to when, on the date on which you start calculating it, where the inconsistency is. But in terms of the amount, you must wait for the conduct standard to be applicable in February. Yeah.
Okay.
Yeah.
So, but then okay. All right. No, then I'm happy.
Okay.
Thank you. Thank you.
All right. I'm just going to unmute Carmen for her to perhaps be able to ask. Yeah, I see I'm able to mute, but I'm actually not able to unmute. So please could you unmute Carmen?
So I've allowed their mics. They can just unmute on their side.
Thank you so much.
Hi. Sorry, just that question that we had on the induplum on the late payment interest and the prescription. The Office of the Pension Fund Adjudicator confirmed in our FI7 webinar that they had a week or two ago that it does apply and that they're applying it to their matters.
Yeah. Carmen, so I'm sorry, I am aware of that. What I was clarifying is one, especially on the prescription, there's different, you can't just apply it straightforward on the 3 years. There are different things that they look at. Okay. But we had initially included in the conduct standard, the induplum rule, we had included it. I know internally when we were finalizing the conduct standard, there were some debate about whether we should leave it in there. But as I indicated, our issue became what would we consider the principal debt? For instance, a case in point would be on Gia's discussion now on outsourcing the recovery of the arrear contributions. Initially, we had actually said it would also include the attorney's fees. But like I said, you will see that it didn't make its way into the final one. And so as much as it's being applied on a case-by-case basis by the adjudicator, in terms of what is written in our law right now, it is not being applied. So, I mean, we're having a meeting with them tomorrow. It is one of the things, especially in terms of prescription, to see whether it must be written into law on whether it will be applied or not. And the independent rule will be the other issue that we'd need to discuss. As you'd know, some of the times, you know, when you're looking at a case and making an adjudication on a matter, you could include, I know they include the equity and fairness standards. That's not something that's written into our law, but it is something that you can use in terms of precedent or other methods of calculating a particular interest or capital amount that's repaid. All I was saying was it's not written into our law at the moment. That's all.
Yes, of course. But they specifically obviously dealt with it in relation to late payment interest on contributions.
Yes.
And confirm that they're applying it. So
yeah,
just some clarity, since we have, you know, different things coming out. And from that perspective, it seemed like they applied it as almost a common law principle.
Yes.
So yes, just if something could go out, because there's obviously a bit of confusion in industry, but I hear what you guys are saying, and obviously with your prescription, you know, it's such a interesting topic. When does it apply? When does it stop? As soon as, I mean, if there's a legal proceedings, prescription stops, for instance, as well, or adjudicator matters. So, but yeah, there is a bit of unclarity. And
okay. I see Carmen has just dropped off, but perhaps we could take Mr. Stratton's question, Michael Stratton, next.
Michael, can you just unmute yourself? Hi, Michael. Can you please unmute yourself?
Okay. It also seems like he's also now, or well, maybe might not be able to.
No question. Sorry.
You might go. Yeah.
You just posted in the question in the chat box that it's no question. It was from earlier.
All right, no problem. Nomsa Makagula.
Nomsa, we have allowed your mic. Can you please unmute on your side?
Okay, we seem to be having an issue there as well. Yeah. Perhaps if there aren't any other questions in the chat, I think you have definitely covered my late payment interest presentation, and really it was actually more clarification. And the only thing that I will do now is just to add on to the presentation on for practical purposes, just on the calculation. Can everyone see my presentation on this side? I wonder if I shouldn't make it. Okay, there we go.
Yes, can.
All right, now I'm sharing the wrong slide. Let me stop sharing and then try again. Okay, so as Kia mentioned already, the interest in Section 13A would have been the first day following the expiration of the period. But I've just given you an example at the bottom to say if the contribution was due for April, the date the contribution would have been due would have been the 7th of May. Then if it's received on the 15th of May, the date that interest is payable is then from the 8th until the 15th. So that is in terms of Section 13A. What Regulation 33 would have given you as an example is the same April, the 7th of May, and if the fund received it on the 15th of May, then the calculation for the interest would have been on the 1st of April. So because it talks about the first day of the month following the expiration of the period. And then, yeah, that's basically it. So for right now, this is the conduct standard. It aligns, section 13A with the conduct standard so that there's no confusion going forward. I know, I definitely been applying it in terms of the first of the month. And I actually recall having a heated debate with the electrical contracting industry fund when we had an on-site at some point. And they were saying, look, we only calculate interest for someone the day that they are then late. I think it was actually Mark who said, but why would you then start calculating it from the 1st if the person was only late, from the 8th? So Mark, you were correct. In terms of the regulation, the way that we had been actually doing it at on-site visits and reviewing it in terms of compliance would have been incorrect, or at least not aligned with what the Act was stating. And now everything would be on the same premise. So I'll make that presentation also available, even for the people that came in the previous webinar, so that because we had said to them, we'd just issue a clarification note as well. And that should suffice to just make sure that we are applying it the way that it's supposed to. I don't know if there are any other questions in the chat here. I am able to see what is in there. Are there any other questions from the floor that we could take? Otherwise, I think that's it from our side. Other than just to speak to Ronel's last question about whether if an employer is jailed, would the contributions that are outstanding then not be payable anymore? The answer there would be no. So that would be a criminal matter where the person is jailed, but there would still be a civil case for them to answer to on the contributions that are still outstanding. So it wouldn't necessarily immediately wipe away the liability of them paying back the contributions. I don't think I've missed any other question.
Takalani?
Yes.
So there are questions actually in our Q&A.
Oh, goodness.
There are questions in the Q&A. There's just one here from Anonymous. It says, will prime plus 2% apply to all outstanding amounts, regardless whether it is the value, regardless whether the value is over or below 10,000, as was previously?
Yes. So the answer is yes. It will apply to any amount. It will not be calculated in the over 10,000 or less than 10,000 amounts. It is a straightforward prime plus 2% on any amount. Yeah.
Right, thank you.
I know we received a question already from our regulatory framework department on that because someone had requested it, and we did clarify that it will apply on the amount straightforward. Yeah.
All right, and then there's another question here from Anonymous. It says contributions are receivable by the 7th after the due date. Does the FSCA apply this rigidly, or exceptions can be made in certain circumstances? If so, what would those circumstances be?
Okay, so the only exceptions, and I think we spoke about it when Gary raised his question about whether the 7 days would be applicable all the time, and some employers aren't able to contribute timeously. The answer would be if you don't have an exemption from that 7-day period, then yes, you would need to apply the 7 days, and it will be applied, to the letter of the law. You didn't contribute on the 7th, and so there would be late payment interest that is applicable. We have previously received some requests to say, look, it was just a banking issue when the money was actually there, and as Mr. Wiese indicated, the whole point is that members would have actually had some investment return coming in had the amount been contributed on time. And so, to start debating whether we can give an exception here and there, we won't have a set time frame. So if you feel a lot of your employers are not contributing by the 7th, then approach the FSCA to see whether you can be granted an exemption for everybody to then, for it to be allowed by the 7th. Bearing in mind that, I understand that it's a difficult situation for the bargaining councils because you've got so many employers and you've got other contributions that come in. But if it's an employer such as the FSCA, we get paid on the 25th, and so the employer having an extra 2 weeks to contribute, you really don't want to then work on an exception on 2 or 3 days where you are late. So again, the time period is very important.
Thank you, Takalani, for answering the questions on my behalf. So there's two more. So there's 2 more questions, right? There's just one related to LPI, and then there's another one that's related to registration of PEs. But I'll start with this one from Anonymous, posted 2 minutes ago. It says, "Hi all. What happens if the fund already charges interest, but the interest that it charges is a higher percentage than the percentage outlined in the conduct standard? Is the drop not impacting members negatively?"
Okay. Kia, do you want to take that one? I seem to recall you saying I answered some of your questions, so I'm at, maybe you want to take that one. Yeah?
I'm still here.
Oh, okay.
Can you take that one, please?
Okay. So yes, I would understand if the fund was saying, we were actually charging more, and I believe that we might have dealt with this at the previous webinar, if not the one for the municipal funds as well. And I don't want to say unfortunately, but you have to apply the interest that is in terms of the Act. Otherwise, the employer can actually come back and say the fund is contravening the Act by not applying the proper late payment interest that is actually there. So you actually shouldn't be applying one that is not in line with the one that is prescribed. That would be the simplest answer, yeah.
Thanks, Takalani. Okay, so Anonymous is asking for clarification on the effective date for the conduct standard. I do realize in the presentation I did say mid-January, and I meant to say mid-February. So it will be mid-February, as that will be 6 months from the publication date. And then the question from Mongezi Ngobo. He said, "Hi guys, thanks for the segment. It has been really helpful. I would like to understand why the registrar authority does not accept terminations logged with the CIPC as proof of termination for a participating employer." I don't know if Elvis or Silindile can come in to assist us there.
Yeah, Elvis and Silindile have to come in to assist us there. Elvis, would you like to take that one, or Silindile?
Well, sorry, thank you. I didn't understand the question. Like, I would, if I understand, maybe Kika, can you repeat it, because I think the answer from my side would be the process are totally different. The IPC one would be different from the FSCA one. So can you just repeat the question so that at least I understand what it means?
Okay. He says, "I would like to understand why the registrar does not accept terminations logged with the CIPC as proof of termination for a participating employer."
Well, yeah, no, I think the authority has definitely outlined its own process of how the employer should be terminated. And we do sometimes, if such information is not available, like there is something that is missing, we do also advise funds to apply for an exemption if they can't provide information that we need. So that would definitely be separate. That's what I can say in the meantime.
Thank you very much, Mr. Madumo.
Right. Kia, any other questions, are there?
It's just one more here, and I'm not understanding it as I'm reading it. Maybe you guys will understand. The 7 days, does it only have to be only in the 7 days of the new month, or 7 days after receipt of funds for employers that would have collected the contribution?
No, it's the 7th of the month. Section 13A3, I think Roman numeral 1, or yeah, section 13A3A is very clear. It speaks about the 7th day of the month for which the contribution would have been due. And remember, we spoke previously or in the previous webinar that it's actually in arrears. So if it's in my example of April, it would be due by the 7th of May. So it's not, if you know, my example of the pay slip or the pay in terms of the FSCA, it's not 7 days from the 25th of when the employer or the member's deductions were made. It'll be the 7th of the next month for which the contributions are due.
Okay, all right. There aren't any more questions in the Q&A.
Okay.
Yes. There's just a comment from Mr. Alistair Dumini in the chat. And I don't know if you saw it, he said, regarding the application of new LPI, we are applying it now because it is less punitive than our previous basis, but it's not retrospective.
Okay, yeah. Like I said, look, it's only applicable in what Keabetswe outlined. I think it's applicable from the 19th of February. I would definitely not think that, you know, especially where whether it's less punitive or not, the issue is it shouldn't be applicable at the moment. Because the conduct standard is only effective, and that calculation is only effective from the 19th of February, to be exact. So it shouldn't actually be being used because, like I said, an employer can come, well, in your instance, because it's less punitive, they probably won't come. But a member could actually say that I'm actually getting less interest, or the fund is applying a different standard, and until the new conduct standard comes in, it actually isn't correct. So I would say please wait until the conduct standard is actually applicable, so that if during this period anyone complains or your matter goes, you know, for review, whether it's you reporting an employer or anything like that, that the fund is not found wanting in terms of applying its rules and also the provisions of the Act and any other regulations or sections of the Act that are applicable for the late payment interest. Yeah, I think I think we're done.
Yes, it doesn't look like we have any more questions. I don't know if someone's got a burning question and they want to raise their hand, but besides that, we are good.
Okay. So I want to send out again a very big thank you to our speakers. Thank you so much again for making the time and imparting your knowledge, and really appreciate all the questions that have come through and the debates and comments that you've made. It can only make processes and policies better for us sharing information. And thank you very much for your attendance. I think we'll just definitely make sure that in our next session, we don't have any confusion about the links. But our last session in terms of the webinars for the bargaining councils and the industry funds will be next week on the 30th. And we'll make sure to issue the program as soon as possible. But it will be over the same time period. So it will be from 9 o'clock until around about this time. And we're looking forward to seeing you then. But thank you so much for your attendance. And please, the presentations will be available and the recordings will be available, but only at the end of the series of the webinars that we're holding for the bargaining councils. Thank you again very much, and enjoy the rest of your afternoon. And we'll see you next week. So thank you very, very much. We really appreciate your attendance.
Thank you, Madam Chair.
Thank you, Gia.